Good afternoon, everybody, and thank you for coming out to the Ethics Game Show today. I hope you are enjoying the other presenters that you've had. But my name is Kimberly Schreiber, and I am a local attorney here in Memphis. And so you will notice that everyone has in front of them a remote control. We are getting ready to go through a set of slides, and I'm hoping that this is a fun way for us to get some ethics hours today. Um, so I'm going to let you practice on the next few slides. It's really easy. There's a hub here in the middle of the room. Just point your remote control at the hub, not at me and not at the screen because it won't work. So I'm going to give you a few test slides before we get going today, and we will see how it works. All right, so on the screen in front of you is a word scramble. And so pick the letter that you think is the correct answer. So is it A, B, C, or D? All right, looks like everybody's getting the hang of it. Keep putting or pointing your remote controls right at the center hub. I'm going to give you about 5 more seconds. All right, let's see how it goes. So correct, everyone in the room got it right. The answer is A, and the word is ethics. Let's try another slide. The next one. All right, so this one's a true false. So true or false, Pokemon game is the best game ever. Pokemon Go is the best game ever. Is it A, true, or B, false? Waiting on about 6 more people. All right, let's see what the room thinks. All right, so no Pokemon fans in the room. 100% of you say false. McDonald's has the best fries. Do you strongly agree, agree, neutral, somewhat disagree, or strongly disagree? Okay, everyone's getting the hang of it now. 100% of the votes are in. Okay, so you can see how that's split out in the room. So going forward, all of your voting is anonymous. And so I'm not going to single you out and say, oh, look, so and so in the room got that answer incorrect. But we're going to go through several different ethics scenarios, starting with Rule 21. Rule 21, let's talk about it. The first question, what does Rule 21 govern? Does it govern A, ethics, B, mandatory CLE, or C, professionalism? Lock in your votes. Remember, pointing at the hub, not me and not the screen. All right, so the answer is B, mandatory CLE. Rule 21 governs mandatory CLE. You'll see that there's normally a star beside the correct answer, and then you can see how the room voted. So 40% of you got it correct. Let's look at our first scenario about Rule 21, mandatory CLE. Jim is a licensed attorney in Tennessee. How many hours of CLE does he need each and every year to satisfy the requirements? Is it A, 12 hours, B, 3 hours, C, 15 hours, or D, 6 hours? Okay, the answer is C, 15 hours. So again, a little over half the room got it right, but we have 15 hours of CLE requirements that have to be met every single year in Tennessee. Let's move on to the next slide. Is the following statement true or false? 3 hours are required for ethics and professionalism in Tennessee each year. Is that true or is that false? 3 hours of ethics and professionalism. Okay, so the answer to that is true. Yes, we need ethics and professionalism. Those are also called dual hours because they can be counted for ethics hours or they could also be counted as regular CLE hours if you've already met your 3 hours of ethics and professionalism hours. Kara has 11 hours of CLE as of September 30th. What is her completion deadline for CLE this year? So, in other words, what is the deadline without any monetary penalties or anything like that? When is the completion deadline for getting her 15 hours of CLE? Is it A, January 31st, B, December 31st, or C, March 31st? Need about 3 more people to lock in their votes. All right, let's see how you voted. All right, so we have a room full of geniuses today. December 31, yeah, so that's our completion deadline, again, without penalties incurred from the commission. How many CLE hours can you forward to the next year? In other words, if you've already gotten all of your CLE hours for this year and you have a few extra, how many of those hours can carry forward? Is it 1 year's worth? Is it 15 hours? Is it 3 hours of ethics? Is it 12 hours? Or is it any of the above? I forgot to tell you that you can change your answer as many times as you want during the voting period. So until we go to the next slide to see the results, you can change your answer. So if you voted something early on and then thought, oh, well, I want to change my answer or that probably wasn't right, you can change your answer anytime during the voting period. How many CLE hours can you carry forward? All right, so the answer is E, any of the above. So 1 year's worth is the same as 15 hours. You can carry 3 hours of ethics over or 12 hours if you only had 12 hours. So any ethics credits in excess of the annual requirement will be carried forward to the subsequent year's requirement. Does anybody have any questions? All right, we'll move on to the next slide. So as you're probably aware, we have in-class and out-of-class or online classes that you can have every year. So what is the minimum number of in-class CLE hours each and every year that you have to have? The bare minimum. Is it A, 5 hours, B, 12 hours, C, 8 hours, or D, 15 hours? Okay, let's take about 5 more seconds to vote. Okay, so the minimum number of in-class CLE hours that you have to have every year is 5. And what you need to know about that is the commission says that an in-class hour is your face looking at my face. In other words, we can touch each other like we all are here today. This is considered an in-class hour if you are here with me live and you can see me and ask me questions and those sorts of things. So those 5 in-class hours are required every single year. Any questions? All right. Let's look at the maximum number of distance learning hours. So those are those online or any other webinar, even if it's live, if you're not face to face with the instructor. So what is the maximum number of distance hours that you can get every year? Is it A, 5 hours, B, 12 hours, C, 8 hours, or D, 15 hours? All right, so a maximum of 8 hours of credit per year can be earned in a distance learning format, according to the Tennessee CLE Commission. Everybody in the room got that right. I bet a lot of you take those 8 hours online every year. It's a little bit more convenient than driving out here and paying to park and hanging out with us all day. James took a course about the parenting plan. The provider gave the seminar on Google Chat. Is the following statement true or false? He can earn credit in this manner. Is it A, true, or B, false? James can take a class about a parenting plan over Google Chat. Yes or no? True or false? All right, so the answer is A, true. Credit can be earned through online, telephone, conference calls, computer interactive seminars, all of that. And those, again, are deemed as not those face-to-face credits, but distance learning. And so going back to the other slide, you saw that you have to have 5 hours of in-class hours, and the maximum you can have of distance hours is 8. Well, 8 plus 5 is obviously not the 15 hours that you need every year. So what that leaves out are credits that you earn for teaching a seminar, or maybe if you are mentoring someone. We had a great mentorship program here in Tennessee where you could earn hours that way. So face to face, like sitting in class, is not the only way to get hours that aren't distance learning hours. Any questions about that? I think the key to remember is just those online credits. The maximum is 8, and then anything else you're doing, if you're volunteering at the Memphis Area Legal Services Clinic, or you're coming over to volunteer at our pro bono clinic, or you're doing mentorship or other things, it's not just sitting in a chair and listening to someone lecture for those in-class hours or those other hours. Okay, great job. Let's move on. When is the CLE Commission deadline for mailing your annual report statement to you? Is it A, December 31st, B, March 31st of the next year, or C, January 31st of the next year? Let's take about 5 more seconds to lock in the votes. All right, so the answer is, with 40% of you getting it right, January 31st of next year. A lot of you should have already received kind of a preliminary statement in the mail. This is kind of the time of year that they send that out to you and let you know, hey, you've got a couple months left of this year to finish up your requirements and this is where you stand, it usually comes to you in a colored envelope on colored paper. And it's a lot of times it's blue or pink or yellow. I think those are the three kind of different colors that I've seen them use. So it's great to know that the CLE Commission also has a deadline. We have to get all of our credits in by December 31st, and then they have about a month to put together all the reports to tell you whether or not you have a deficiency for the previous year. So on or before January 31st of each year, the Commission shall prepare and mail an annual report statement to each attorney covered by Rule 21. It will tell you whether or not you are in compliance for the preceding calendar year. And if you are not, we're going to go through the deadlines and the fees that you have to pay. True or false, you cannot earn CLE for teaching CLE classes to other attorneys. Is that statement true or false? All right, about 5 more seconds. There's still time to change your vote. All right, great job. Everyone got that right. So the answer is B, false. You definitely get CLE credit for teaching classes to other attorneys. I usually have well over 100 CLE credits every year with all of the mediation training we do and all of the end of the year CLE blast and the monthly things that we run here at Training Resolved. Olivia creates a 1-hour CLE class on the 2016 legislative updates. How many CLE credits will she get the very first time she teaches the class? Is it 2 times credit or 2 hours? 1 hour? Is it 1 for 1? Is it 4 hours? Or is it 3 hours? Remember, she's teaching a 1-hour class. So how many hours will she get because she is the instructor? All right, so the answer is actually 4. It's 4 times credit. So the very first time you teach a class that you develop, you get 4 hours of credit per 1 hour that you teach. So if she taught 2 hours, she'd get 8 hours credit. Now, that goes down the next time she teaches it. So if, like this ethics game show, we've run that, I think, 7 or 8 times this year. And so the very first time I taught it, 4 times credit. After that, 2 times credit. So if anyone here is interested in developing their own CLE class, we would love to have you come over and run something here at our headquarters here at Training Resolved. So let's say you're disabled. Alex is disabled. What can he do for his CLE this year? Can he A, just skip it? He doesn't have to do it. B, does he need to file an affidavit of disability? C, does he need to file a petition for exceptional relief? Or D, is he allowed to complete all 15 hours online? He's disabled. Still waiting on about 8 or 9 people. All right, so about half of you in the room got it right. You need to file something called a petition for exceptional relief with the CLE Commission. That's how you put them on notice that you actually are disabled, and they have to approve that petition. You definitely cannot skip it. And if you complete all 15 hours online, you're only going to get credit for 8 of them. Who is exempt from CLE? Is it active duty armed forces? Is it B, full-time professors, law professors that are not practicing law? C, federal judges? D, attorneys over 70? Or E, any and all of the above? Who is exempt? Waiting on about 5 more people. I'll give you about 5 more seconds. All right, so the answer is E, any of the above. So if you are active duty armed forces, a full-time law professor, not just any old professor, but a law professor, and you are not practicing law, because a lot of us do adjunct stuff, or you're a federal judge, or you're an attorney over 70, you are exempt from CLE. Any questions about that? All right, thank you. So, true or false? If I am eligible for an exemption on December 31st, I can claim the exemption for the entire year. Is that statement true or false? If you're eligible for an exemption, you can claim it for the whole year. True or false? Okay, so the answer to that is true. And let me go into a little bit more of an explanation. So if you're eligible for an exemption on December 31st, you can claim the exemption for the entire previous year. However, if you lose your your eligibility for an exemption before September 1st, then the commission looks at that and says, well, you have all of September, all of October, all of November, and all of December to catch up those 15 hours. And so you have to meet the requirement for the entire year. But if you lose your eligibility after September 1st, you can still claim it for the full year. A letter outlining the circumstances and the requested relief is usually sufficient for the commission. And you can ask the commission for exceptional relief. We talked about that earlier. So again, remembering that if you're eligible for an exemption as of December 31st, you have it for the whole year. But if you have it for the first 9 months of the year or 8 months of the year, and then you're deemed okay and you're no longer disabled, the commission says, all right, you've got those last 4 months of the year, you still need to complete all of your hours for that calendar year. Any questions? That can be a little bit confusing. All right, no questions. True or false, the deadline for attorneys to complete their annual report statement is March 1st of the following year. True or false? Great job. Everybody in the room got that right. So, on or before March 1st, each and every attorney has to complete their annual report statement indicating that they have either complied or that they're exempt from the previous year, and they have to deliver the completed ARS or annual report statement to the commission. On the next slide, we're going to go over a little overview. So by March 31st each year, the CLE Commission has to compile first a list of every attorney who did not timely file their annual report statement for the preceding calendar year. So remember, we have until March 1st, after the end of this year, to timely file our report statement. The commission also has to compile a list of any attorneys who timely filed their report statement, but they admitted, hey, I didn't comply with the requirements for the preceding calendar year. I'm still deficient. And the last thing that they're going to put together or compile is a list of attorneys who timely filed their annual report statement. They completed all their requirements for the rule, but they didn't pay their fees on time. So the commission does that on or around March 31st every year. They're really busy that time of year. So make sure that you're getting your CLE in by December 31st. The commission is getting their report statement to you by the end of January, and then you have to get it back to them by March 1st. So if there's an error, if your hours didn't get reported correctly or they didn't get paid for or something like that, you have all of February to clear that up and get your report statement in by March 1st. And they'll fix that. They're really good about that. They're really good about making sure that if they've made some sort of error, or one of your providers who was supposed to report your hours has made some sort of error, they're pretty good about fixing that. Our guarantee to you is we always report your CLE hours the same day you take a seminar from us, because we don't ever want to get to the end of the year and have somebody think they have a deficiency. Now, just because we are reporting doesn't mean that the commission is going to process that. They're really good. They usually process it within 2 or 3 days, and you'll get an email, and we'll get an email that verifies that. So if you haven't seen that show up in your account, or you don't get an email, wait about a week, and then you can either contact us and make sure we reported it, which we've never not reported it, or you can call the commission or send them an email and say, hey, it's been a couple weeks and I took this seminar and I'm just wondering if it got reported correctly. We get those emails from people a couple of times a year, and it usually turns out that the person who was reporting that was sick, or they were on vacation for a week or something like that. But the commission will clear all that up. That's another great reason not to wait till the end of the year, until December 29th, to take your CLE. All right, let's take a look at some of the fees if you don't take your CLE in a timely manner. Mary Jo filed her annual report on May 30th. Obviously, that's well after the deadline. What is the non-completion fee? What will she be required to pay? Is it A, $100, B, $200, or C, $500? What is the non-completion fee for filing May 30th? All right, let's take about 5 more seconds to get those votes in. Okay, so the answer is A, $100. Each attorney who gets a notice of non-completion has to pay a fee of $100. That $100 fee is due on or before May 31st. So she got that $100 fee one day before the deadline. So it's $100 until May 31st, and it goes up after that. Let's say Mary Jo filed her annual report on June 12th, again, well after the December 31st deadline and after that May 31st $100 deadline. Now, what is her non-completion fee? Is it A, $100, B, $200, or C, $500? Alrighty, the answer is B, $200. Now, remember that if you can show to the satisfaction of the executive director of the CLE Commission that your notice of non-completion was issued erroneously, you will not have to pay that fee. Let me give you a couple of examples of times when we've had our clients come to us and tell us that there's been some sort of error. We had a client one time that had applied to waive in from another state into Tennessee. And they got their application to the commission in October. The commission didn't vote on that waive in until the next year. So they voted, I think the client said the commission voted on it sometime in late January or early February. They voted yes to waive the attorney in, and the attorney got an official document from the state of Tennessee that said, as of March 26th, their waive in was approved. Well, then on March 31st, they got put on the list of non-compliant attorneys that didn't meet the 15 hours for the previous year. And so the client just wrote a quick letter to the executive director of the commission and said, hey, wait a minute, although I applied last year, I wasn't approved and couldn't practice law in the state of Tennessee until the next year, this year, so do I have to go back and do I have to pay this fee? And the executive director said, oh no, sorry, it was a computer glitch. You have a BPR number, and it's no problem. We had another case where an attorney had paid the $100 fee and they had mailed it off. And in their office, their paralegal or their secretarial staff kept something called a mail log. Does anybody here have a mail log? We have one here at our office. Okay, about half of you. All right, so what they did was they contacted the commission and they said, hey, we wrote this check, it never cleared, we don't understand, we mailed it out, here it is in our mail log. If you want to talk to the keeper of the records, right, if you want to talk to our secretary or our paralegal, this is how we can prove, we logged it in, this is the address, this is the date that it's mailed out, this is the check number that's missing in the middle of our check registry. Do I have to pay the $200 or will the $100 be sufficient? And in that case, the executive director of the commission said, oh no, that's fine, that's enough proof. That was the attorney showing to the satisfaction of the commission that they had tried to comply. Okay, let's move on to the next slide. Bob fills out his annual report, but the CLE Commission misplaces it. He will have to pay a $100 fee by May 31. Do you A, agree, B, somewhat agree, C, are you neutral, D, somewhat disagree, or E, disagree? So he fills it out, the commission misplaces it. Will he have to pay the fee? All right, so the answer is usually disagree, and that goes back to the example that I gave you right before we talked about this slide. Um, he's not going to, if he can show, if Bob can show to the satisfaction of the commission that he filled out the report, then he will not have to pay the fee. The other thing you need to know is that the CLE Commission is trying to go to an all online system. And so they really, really want you to make sure that you have your correct mailing address and, more importantly, your correct email address so that as they're transitioning to an online only system in the next couple of years, that you will make sure that you're receiving any emails from them, because they would like to stop paying for snail mail, right? And start paying or start sending out emails and allowing you to view that online and pay that online. The final date for completion of CLE before your license gets suspended is July 31 of the following year. Is that statement true or false? Final date for completion of CLE. Let's take about 5 more seconds. Okay, and the answer to that, 100% of the people in the room got it wrong. The answer to that is false. The correct answer is August 15th. And let's hope everybody got it false or got it wrong, because no one's ever putting themselves in this position. But let's take a look at it. So on July 1st, every year, the Commission prepares a draft suspension order listing every attorney who got those notices of non-completion and who failed to remedy the deficiencies by May 31st. So they're putting all that together on or about July 1st. The Commission submits that draft suspension order to the Supreme Court for informational purposes only. And they're obviously letting those attorneys know that as well. On August 15th, the Commission submits to the Supreme Court a final suspension order. And that lists every attorney with an active Tennessee law license that failed to comply with Rule 21 for the preceding calendar year. So on August 15th, the Commission also notifies the Board of Professional Responsibility, the BPR, of the names of all those attorneys who have either retired or taken inactive status, or who have been suspended, or whose license to practice law is somehow otherwise inactive. The Supreme Court then looks at that final suspension order, and then they will approve or deny the people's names, the attorneys that are listed on that order, and they will sign and enter a final suspension order on August 15th that suspends the license of each attorney who is listed in the order. So just make sure, we've got people, for some reason, at the end of July, every year we have people scrambling to get those suspension, to get their hours in so that they won't be on that final suspension order. And by the way, the fee for that is $500. So if you just missed the boat, or you didn't realize, or you were 1 or 2 hours short and you've waited until the end of July, it's a $500 fee to get your license, pulled off that draft suspension order list and to be compliant with your fees that you owe to the CLE Commission. Any questions on that? All right, that completes everything that we are going to learn today about Rule 21. And you will know that we are at the end of a section because we're going to throw in a silly word scramble slide or some other kind of fun slide like those few learning slides we did at the end. So let's take a mental break and look at that. Fill in the blank. Which letters in this word scramble complete the word? A, B, C, or D? You still got about 5 or 6 people voting. All right, so the answer is D, and the word, just in case you got it wrong, is pro bono. Pro bono. Compliance overview. Let's talk about it. Okay, so this is just a brief overview. December 31st, you have to complete your 15 hours, and that's without late fees. January 31st, annual report statement is mailed to you by the CLE Commission. That is their deadline, not yours. March 1st, you, the attorney, has to complete and mail your annual report statement to the Commission. March 31st, the Commission is sending out those notices of non-completion, obviously only to non-compliant attorneys. If you're compliant, you're not going to get anything. May 31st is the deadline for mailing affidavits of completion and paying your $100 fee. Fees after the 31st go up to $200. June 1st, that's when that $200 late fee kicks in. And that's what you got to pay to get off that list. July 1, draft suspension orders are sent to non-compliant attorneys and to the Supreme Court, the Tennessee Supreme Court. Remember, those are just a draft. They're not a final order yet. You still have time if you had something else going on. August 10th is your deadline for filing an affidavit of completion and paying all your fees. Again, that's a $500 fee, right? So as not to be included on the draft suspension order that's submitted to the Supreme Court. August 15th is the day that the Supreme Court signs the order suspending licenses. That's also the day that the Commission notifies the BPR Commission of the names of the attorneys. Any questions about the compliance overview? The moral to the story is get it in on time and get a few extra hours for the next year. You'll be that much more ahead. Let's look at another fun slide. Rocket is to space as submarine is to A, cave, B, sea, C, land, or D, air. We should have made C, C. Get those answers in. 2 more people. Remember, pointing it at the hub, not at me and not at the screen. All right, 100% of you in the room got that correct. Rocket is to space as submarine is to the sea. Let's move over into one of my favorite topics, which is Rule 31. Rule 31 for mediators in Tennessee. Let's talk about it. Is the following statement true or false? There are 3 different types of mediator certifications in Tennessee. And notice that I put the word certification in quotes because Tennessee does not certify mediators. But are there three different types of certifications or listings in Tennessee? Is that statement A true or is it B false? That statement is A true. And so one of the things that we are passionate here about at Training Resolved is mediation. We are ADRC approved trainers for all three areas of mediation training. So those three areas are, the first area is family, family mediator, mediators that can take family law type cases, juvenile court, parenting plans, parenting plan redos, all that stuff. The second area is the general civil mediator. Those are the mediators that are doing car wreck cases, personal injury, construction cases, landlord tenant law cases, those sorts of things. And then the third listing that you can get through the Tennessee Supreme Court through the Alternative Dispute Resolution Commission, otherwise known as the ADRC, is a specialty certificate, or I'm sorry, not certificate, listing called Specially Trained in Domestic Violence Issues. And that is a 12-hour class, and it goes directly with the family listing. Domestic violence is for domestic cases. That's not to say that you can't have, people who are angry in a business dispute in a general civil mediation, but domestic violence, that specially trained in domestic violence listing is only for mediators that already have their family training. Family training takes 46 hours if you want that, and 6 hours of that is actually specialty training in Tennessee law. So 6 of those hours kind of get you up to speed with what's going on, especially in Tennessee law. General civil training is a 40-hour class because they're not requiring that 6 hours of Tennessee family law be included. But once you have either family law or general civil listing, you can do crossover training and pick up the other listing for less hours. So if you take family first for 46 hours, you only need 16 more hours of training to get your general civil crossover listing. If you take your general civil listing first for 40 hours, they actually need you to take 30 more hours of training to get your family listing. And then, of course, the 12-hour class for specially trained in domestic violence issues. And that is you're only eligible to take that class if you are family listed. We have a class coming up in March. If any of you are interested in that, interested in getting your listing, we'd love to have you in that class. You can log on to our regular website, which is trainingresolved.com, and sign up for that class. All right, let's move on to the next slide. Carol is an attorney mediator. She is exempt from CME. Is that true or false? So for those of you who are not Rule 31 listed mediators, CME stands for Continuing Mediation Education. So if you are an attorney that is also a Rule 31 listed mediator, are you exempt from CME? Continuing Mediation Education. Is that statement A true or B false? So that statement is B false. You have to take CME every single, well, not every single year, and we'll talk about that on the next slide, but Just because you're an attorney does not mean you are exempt from CME. Okay, so let's look at Rachel. Rachel is a Rule 31 listed mediator in family, so she's family listed. How many hours of continuing mediation education credits does she need each year? Is it A, 6 hours each and every year? Is it B, 3 hours each and every year? Is the answer C, 6 hours every other year? Or D, 3 hours each year and 6 hours every other year? What do you think? Let's take about 5 more seconds to get all the votes in. All right, so the answer is, and nobody got it right, the answer is 6 hours every other year. So they don't care if you take the 6 hours all in one year and then 0 hours the next year, but you have to have 6 hours every other year. They give you 24 months to get those hours in. Another thing you need to know about those hours, that those are self-reporting hours. So you don't get a number like a BPR number if you're a Rule 31 listed mediator. They send you a report and it's on the same schedule as the CLE Commission's hours, which means you have to complete your hours by December 31 every other year. And so they don't care, again, if you take 3 hours in an odd year and 3 hours in an even year, or if you just take 6 hours all at once and then you can skip the next year. They send you a report in the mail, usually comes in sometime in October, and then if you haven't done your hours yet, it's a reminder, hey, I need to get those in. And there's also a $100 fee that you have to pay to keep your listing updated, to stay on that list. So that's also a note to you that are attorneys in the room, that if you are using Rule 31 listed mediators, which I seriously hope you are, if you've been using somebody and it's January and you haven't looked them up to make sure that they are still listed as a mediator, in January and February, that's when I get back on there and make sure every time that I'm hiring a mediator for one of my cases, I want to make sure that they're Rule 31 listed. Why do I want to do that? Well, the first reason I want to do that is because mediators who are listed have judicial immunity, which means they cannot be called as a witness against my client in court. Everything you tell those Rule 31 listed mediators is confidential. There's a few exceptions to those, and if you want to know what that is, you should come take our class in March and get listed. But making sure that you're using a Rule 31 listed mediator to protect your client. And the other reason is if you've got a problem with a mediator and they're listed with the ADRC, with the Alternative Dispute Resolution Commission, if you've got a problem with them, you've got somebody to complain to. You've got a way to, that has some teeth if you have an issue with a mediator, because the ADRC can pull someone's mediator credentials if there's a problem, if there's something that is violated ethics rules, or if the mediator has done something that the rule doesn't let them do. So it's really important that we make sure that our mediators that we're using, if we're attorneys, are getting their CME every other year and they're paying their $100 fee every year and keeping their listing active. Does anybody have any questions about that? All right, let's keep talking about Rule 31. So of those 6 hours of continuing mediation education credits that you have to get every other year, how many of those hours shall be ethics? How many ethics hours? All right, so that's just 1 hour of ethics that you have to have of those 6 hours every other year. True or false? CLE courses are always approved for continuing mediation education credits as well. Is that true or false? If it's CLE, it's always CME. Is that true or false? Let's take about 5 more seconds. So the answer to that is false. So let's say that you are that you take a class in like a DUI class or something like that. That really doesn't have anything to do with mediation, and so the commission is not going to approve that for CME. You can get a list of all of the classes that are approved for CME. If you're in this room and you happen to be a Rule 31 listed mediator, let me see by a show of hands how many of you are Rule 31 listed. Okay, great, great. There's several of you in here. What you also need to know is that this ethics class is approved um, for CME as well. So we've submitted that to the ADRC, the Alternative Dispute Resolution Commission. We've submitted this class and they've approved it. So if you need that 1 hour of ethics, or you want to take all 3 hours that you're taking today and put that toward your CME, you can do that. This is an approved class. Yes or no? Are the CME requirements different for general civil listed mediators versus family listed mediators? Are they different? So the answer to that is yes, they actually are different. Just like the family listing class is 46 hours, it's a little bit more. The requirements for family listed mediators are a little bit tougher. And so what the commission is telling us is that of those 6 hours every other year, 3 hours of your CME has to be in something specifically related to family law. So a family law update or something like that. Any questions about that? Family listed mediators need 3 of the 6 hours every other year to be in family law type areas. Some sort of case law update, or how to fill out a parenting plan, or changes to the parenting plan and how they affect your clients, or how to be a better drafter, something like that. And we run all those. If you need anything like that, just let us know. So for dual listed mediators, and a dual listed mediator is somebody who has both general civil and family, does meeting the family requirement meet both? So in other words, if you took those 3 hours of family law, can you also apply that toward your general civil? And the answer to that is yes, if you were initially listed in the same year. So if you're going to take training, you need to be kind of careful and make sure that you don't get your family listing in an even year and then your general civil listing in an odd year, because those every other year credits get more complex. For our clients that do that, what they normally do is they take 3 hours every year, and then that is a rolling 6 hours for every other year. Can everybody wrap their brain around that? So if you haven't gotten listed yet, my recommendation is that you get both listings at the same time. All right, so this ends our first hour of the Ethics Game Show. We're going to take a quick break. We still have a few more things to go over for mediators and for those people who are taking it online. We hope that you come back and take the next hour or two with us.